Yeah. So because there's this myth out there that LLCs are a magic bullet, they're not. People act like it's the be all end all of protecting assets, but they're limited. They tell us this straight up in the name. Now, don't get me wrong. Like, I'm not anti LLC. Like, I use them every single day in my structures. The problem isn't the LLC itself, it's how people use them.
Welcome to the Real Estate Pros Show, where we interview real estate investing professionals from coast to coast, as well as the service providers that serve the real estate investing industry. Our goal is simple: share what's working now to help you improve and scale your business to the next level and meet the pros that can help you get there. Real Estate Pros is powered by Investor Fuel, America's leader in helping real estate investors and professionals build the business you need to live the life you've always dreamed of. Let's start today's show. Property insurance for real estate investors doesn't have to be difficult, but it does need to be there to protect you when you need it. MyInvestorInsurance.com not only provides insurance at 15 to 30% cheaper than traditional agencies, it's built specifically for real estate investors like you. You can set up an account in about 2 minutes, get quotes on properties, turn on and turn off insurance for your fix and flip or rental properties in around 2 minutes without having to talk to anyone directly, all through our portal. There's no better way or faster way to make sure you've got the coverage you need to protect you, and no more lengthy policies either. Once you're set up, you're billed monthly and prorated by the day for however long your policy is active. It's powered by MSI, the third largest independent MGA, with 1.5 million customers and more than $1 billion in cumulative premiums written. Get set up today in about 2 minutes at myinvestorinsurance.com/fuel.
Hey, everybody. Welcome to the Real Estate Pros podcast. I'm your host, Michelle Kesil, and today I'm joined by someone I'm looking forward to chat with, Brian Bradley, who does asset protection for investors. So excited to have you here today, Brian.
Thanks for having me on. This is going to be a necessary conversation, especially now. Like, we're living in a moment in time where the, legal and regulatory landscape is shifting really fast, and especially depending on who's in power at the time. And so most people, even successful investors and professionals, are either relying on outdated asset protection strategies, or they're just, being sold a bunch of myths and half-truths that don't hold up in court. So asset protection in today's age isn't a nice to have, it's preparedness. Just like you're not going to go on a camping trip without gear, right? So you shouldn't be building wealth without legal structures. And so today, I'm going to do two things in the time that we have: is bust some scary misconceptions and then try to explain this through some case law.
Amazing. Thank you for bringing that value to our audience. Yeah, excited for you to dive into all of that with us. So first off, for those who might not be familiar with asset protection, can you maybe give a understanding of what that is?
Yeah. So at its core, it's this big, weird word that people hear, but they don't really understand what it even is. And they misconstrue a lot of different areas of law into one. So asset protection is simply putting a legal barrier between your assets and a potential creditor, right? Like the person suing you, try to taking everything from you before there's a problem, and that's it. It's not about secrecy. It's not about hiding money or evading taxes, right? That's illegal. It's about legal structures, not concealment. So think of it like a safe or a firewall. You wouldn't leave your guns, your gold, your gems, or your valuables just sitting out on the front porch for someone to easily take them. You lock them up behind a barrier like a safe where they can't be easily taken. And so asset protection does the same thing for your investments, like your rental properties, your stocks, your bonds, your cash, your businesses, by moving them out of your personal name and behind the legal structure. And then when it's done correctly, it's all going to be tax neutral and IRS transparent. Now, the two rules to determine whether a plan works or fails is timing and control. And if you don't mind, I can explain it through a case law.
Yeah, sure. Go ahead.
Okay, so there's this 2010 case, SEC versus Solo. Here, Mr. Solo got nailed by the SEC for a fraudulent trading scheme. So just think like bad man doing bad things, right? After they hit him with a massive judgment, he moved his assets into his wife's offshore trust, thinking that that would protect them. That's just a classic post-judgment after the fact lawsuit transfer, and the court saw right through it. So he was held in civil contempt of court, and he should have been. But here's the twist. Here's where most people miss. The offshore trust that was set up still worked. The SEC couldn't touch the assets. So two big lessons come from the Solo case. One is that offshore trusts are incredibly powerful when they're structured correctly. And two is that timing is everything. You see, Mr. Solo didn't get in trouble because of the trust. He got in trouble because he acted after the judgment. So that's like trying to buy car insurance after the car accident to cover the car accident. So the takeaway isn't don't protect. The real lesson is you have to plan before the lawsuit hits. So the takeaway is protect early and be honest.
Stop living on an island and join the #1 mastermind in America for professional real estate investors. Investor Fuel is a community of hundreds of the nation's top investors working together to build stronger businesses and better lives. In addition to the amazing community of real estate investors acting as a board of advisors for one another, Investor Fuel members have access to 100% funding on purchase and repairs for our members only, a health insurance program, and benefits and discounts that more than pays for the membership of most of our members, meaning it's actually costing you money to not be a member of Investor Fuel. If you're looking to scale your business and build a business that allows you to live the life of your dreams, please visit investorfuel.com today and book a call with our team.
Yeah, absolutely. That makes sense. Where do you kind of see investors maybe having some misconceptions around these concepts?
Yeah, I think a big one is just the use of LLCs. And before I think we break down like the misconception of LLCs, I think if we take a step back and open up the spectrum a little bit of like what are the different layers that are used and tools that are used in asset protection, then people can understand how they all come together. And so asset protection works best in layers, like dressing to go outside on a cold winter day, right? These tools are LLCs, limited liability companies, management companies like limited partnerships, and then asset protection trust. Where you land in these just depends on the individual's risk profile, their day job, their exposed net worth, like what you own, where you own it at, and each person is going to have their own profile. And just to quickly break down each layer, the first entry layer is your base layer. So think of it like that thin shirt that sits on your skin. This is an LLC. This is when you're like just starting out investing. You have nothing, maybe one rental property, greenhorn to investing. And then as you grow and add more assets and you hit that like 4-unit mark or you're, investing in multiple states and might have multiple LLCs and you have around 500,000, 700,000 net exposed assets, that's when you're going to want a mid layer, which is usually a little bit thicker, generally made out of like merino wool or a cardigan. This is a management company or a limited partnership. It adds another layer of protection and it cleans you up from a tax perspective. So then you can just maintain one tax filing. And then when you hit around that 1 million net worth mark, you have, a high risk job, maybe like a doctor, real estate investor. You want an outer shell waterproof layer. This is going to keep you nice and dry and warm when the weather is really bad. This is your break glass in case of emergency layer. This is your doomsday lawsuit firewall protection layer. Those are what we call asset protection trust, which we'll talk about, later on. But by layering, you're now more flexible. You can adjust to make yourself more comfortable. And each state has different strengths and weaknesses. And at that base level, entry level, that's where LLCs come in at that foundational layer. And that's where I think it's really important, if you want to jump into that, like what are some of the misconceptions with LLCs? Yeah. So because there's this myth out there that LLCs are a magic bullet, they're not. People act like it's the be all end all of protecting assets, but they're limited. They tell us this straight up in the name. Now, don't get me wrong, I'm not anti-LLC. I use them every single day in my structures. The problem isn't the LLC itself, it's how people use them. So think of an LLC like your base layer of clothing on a freezing, stormy winter day. That thin shirt that's sitting on your skin, right? It's not your body armor that you're using. Is it necessary? Absolutely. Is it sufficient? No, it's not even close. So if you think one LLC is going to stop $1 million lawsuit, you're walking into a blizzard in a t-shirt. So courts pierce sloppy LLCs every day. So we need to talk about the reality of LLCs. And I really want to focus on the Wyoming LLC because it's kind of the belle of the ball right now.
If you're looking for consistent, high-quality leads, look no further than Investor Machine. Investor Machine isn't just another agency. It's the most sophisticated, data-driven lead generation company on the planet for real estate investors, and serves the role of being not just a lead generator for your business, but a marketing partner that is helping you achieve your goals along the way. Go to investormachine.com to learn more and schedule a call with our team today.
It's the state that everybody loves to name drop, no income tax and anonymous ownership, strong exclusive charging order laws. And so it all sounds good and it is great, but it's only good for privacy. But privacy is not the same thing as protection. And I want to say that a different way. Privacy does not equal protection. Privacy is just camouflage. It hides you from public records and nuisance lawsuits. But once you're in a courtroom, privacy completely disappears. Courts can subpoena your bank accounts, your title companies, your property management. They can find out exactly what you own in minutes. And people think that they can hide behind a registered agent or hide behind a service company or hide behind a nominee, and that they just can't be reached, that they can just ghost a lawsuit. And that's just completely wrong. Those are just forwarding mailboxes. They exist to receive service of process, not block it. So when someone files a lawsuit, that agent is legally required to accept service on behalf of you and forward it to you. The lawsuit will still find you. And here's where it gets even more real. Promoters are going to tell you just form in Wyoming and you're protected everywhere in every state. No, you're not. Once you're in court in like California, New York, Florida, Texas, Illinois, like the big states, right? Guess what? That court applies its own laws, not Wyoming's law. And this was hammered in the Mallory versus Norfolk case. So if your company is registered to do business in a state, that state can assert jurisdiction over you, period. You can't buy better laws from another state that you have no legal connection to and bring them to that state. It doesn't work that way. So what you're doing is mixing up business law and tort law. So if someone trips on your property, this is a great example, and cracks their skull open, that's tort law, that's damage law, not a business dispute. So that's not a contract dispute. So if you have like a mold or lead poisoning issue in your rental property and a family member gets sick and they sue you, that's a personal damage tort claim, not an internal business affair dispute. So state law controls personal injury lawsuits. So no Wyoming LLC operating agreement is going to save you from negligence, and the receipts are clear. The case law is very clear on that.
Yeah, that's super interesting. So when you say a lot of people are wanting to make their LLC in Wyoming, is that applicable to those that live outside of the state?
It just depends on what the LLC is being used for, right? So if you and I were to say, hey, let's go create widgets and sell widgets nationally, right? Then yeah, we can go and use Wyoming. We can use Nevada and Delaware because that's going to give us more credence to the operating agreements for internal affairs and disputes of the business. Like business is winding down, the business isn't working very well, or we're going to sue each other, right? That's when you're going to use like Wyoming, Delaware, Nevada. But let's just say most people that are invest in a lot of real estate rental properties, right? Well, when someone slips off your roof or you're getting sued from a rental property, you and I aren't suing each other. It's generally someone getting injured and hurt. That's a tort liability, right? So tort law is specific negligence law. So there's a different area of law. So in that situation, you're not using the Wyoming LLC as a business. You're using it just as a holding entity, like holding an egg, like a basket holding an egg, right? So there's no business disputes there. So now we're using a completely different area of law. So in that situation, the rule is just use the LLC in the state where the asset is located. So if that property is in Tennessee, Tennessee LLC. If it's in Florida, Florida LLC. If we're going to create a business to sell widgets nationally, yeah, we can use Wyoming or Delaware, but it's more for what happens when the business winds down or you and I need to sue each other and there's an internal dispute in the business.
Got it. That makes sense. Thank you for that clarification.
Absolutely.
Yeah, so I guess kind of like circling back to some like misconceptions and beliefs, is there like anything else that you think investors might be doing or believing that isn't steering them in the most optimal direction?
If you're a new or newer real estate investor looking to launch or grow your real estate investing business, please check out Investor Fuel Club. It's a coaching community, but unlike anything you've ever seen before. And you can actually partner with members of our mastermind from coast to coast on deals right in your market. There's no better opportunity to build a consistent business than to literally partner with pros to help you avoid costly mistakes, avoid the need for capital to do deals, and help you eliminate your fears as you're starting your business. Learn more about Investor Fuel Club at investorfuel.com/club.
Yeah, I think one is just another big one is just misconstruing and understanding asset protection trust. And so, like, as we build these foundations, right, like LLCs, management companies, we get to the ballistic shield, which is creating an asset protection trust. But I think a lot of people think a trust is a trust is a trust. I have an estate plan. I'm covered, right? And you get this misconception even with estate planning attorneys. And the problem is that people tend to lump all of these things together. And it's like saying, well, I have a car, so it must be an F1 race car. Or they create two mental shortcut categories, right? Like a revocable living trust, or they hear self-settled offshore and immediately the brain like defaults to bad because they just don't know any better. But trusts are like, the ice cream store Baskin Robbins. There's lots of different flavors. And so most are not built for asset protection. And so each state has its own laws. And then we also have to deal with federal laws to consider. So a few common types of trust are like the estate plan, the revocable living trust. Great for probate avoidance, naming beneficiaries, but zero lawsuit protection. Like they're not designed for it. They're only designed for after death planning. Then you hear about land trusts for real estate investors. Good for privacy in real estate, but they have no liability shield. So if the LLC that it's connected to gets pierced, the land trust completely collapses. Then you hear about like tax trusts, right? Like Delaware, generational skipping trust, spousal trust. Great for tax planning, completely useless for lawsuits and asset protection planning. So that's where asset protection trusts come in. And that's when you start talking about power, right? A proper asset protection trust is self-settled, it's irrevocable, and has spendthrift provisions. And so as you can see, you got to use the right tool, like use the hammer for what a hammer is for, right? We got hammers, wrenches, screwdrivers, nails. So if you're grabbing, like a screwdriver to try to like hammer in a nail, you're using the wrong tool at the wrong time. So that's where a big misconception that I hear talking to people is, I have an estate plan, so I'm covered, right?
Right. That makes sense. Thank you.
Well, I would say another big one is just not understanding your state's limitations is a really big one, especially when it comes to asset protection trust. Because in the U.S., every state has its own policies, right? So, for example, you have to have self-settled spendthrift legislation for asset protection trust to work. Not every state has them. So like if you're in the big states, California, New York, Florida, Texas, Illinois, they don't have self-settled spendthrift legislation. And so when you're talking to an estate planning attorney who doesn't practice asset protection and they say, hey, just create this, revocable living trust, you're good to go. Or you're a California resident, go create a Nevada trust. California doesn't recognize asset protection trusts. They have no self-settled spendthrift legislation. And so you're just buying a false sense of security. And so you really have to talk to a specialist and realize in my state where my assets are located at and whatever is going on, what is the applicable law that applies to me? And just realize you don't want to buy a false sense of security for a trust that's not going to work for you because your state doesn't even recognize them.
Yeah, absolutely. There's so many things that I'm sure people don't know these little details of.
No, absolutely. And the biggest common one I have right now, I'm not sure where we are on time, is just like I get this common question lately of, you know, can a judge just freeze assets before an asset protection trust, can actually be utilized? Yeah. So this is the big misconception that I'm getting, lately. And it makes the most sense when I talk about it through fraudulent transfers. And I'll explain it through two cases. And these cases are both from Indiana, but it's not an Indiana specific law. It applies everywhere. So at times you hear some people say this, like, and it's a valid question. A hybrid trust doesn't work, that even though they have been around for over 30 years and never been pierced, that the courts can just stop them, that judges can just freeze the assets before you can trigger anything offshore. And then they cite both of these two Indiana investor cases. Now, these cases are real, but the way they're being used and explained is very misleading. And here's what actually happened in the cases. So in Indiana Investors versus Hammond, and also in Indiana Investors versus Victor Fink, both the trusts were fully U.S. domestic asset protection trusts when the defendants were sued. So completely U.S. based trusts. So that's already strike number one. They were fully domestic. So you see, you had a U.S. trustee subject to U.S. courts and judges, you had U.S. banks, and you had U.S. control of assets by the trustee, meaning you. And the offshore, piece of the trust, well, that portion didn't even exist yet. They didn't create it beforehand. So the offshore component was just like a future idea, future possibility that we'll do, something that would happen later on down the line if things went bad. Then later on, after they got sued, after the lawsuit, things went bad, right? Their plan was just then triggered, and the trust then transferred, literally moved the assets out of the domestic trust and into a separate offshore trust. And that trust wasn't created beforehand. So it was meant, it just sounds really bad, right? Like a U.S. trust funded, the offshore component wasn't created yet. We're getting sued. Now let's move assets out of this trust into some other trust. So what did the courts do? They didn't pierce the trust. They didn't reach offshore assets. They didn't even invalidate foreign trust law. The courts just issued restraining orders to U.S. people and to the U.S. banks because those are the entities at the time that still had control over the assets. So that's the key principle here. Those cases don't say like hybrid or offshore trust bad. They fail. What they said is this: if you wait until a threat exists, and once that threat exists, if control of the asset is still in the U.S. and it's still in your name at that time, and if it's still in your control and in your name at that time, then the U.S. courts can freeze those assets that you still have jurisdictional control over. And that just makes complete sense. So that's not a geography problem. That's a timing and control problem. So they set the trust up improperly from the beginning. So why are hybrid trusts structured differently? Like, what's different about them? A properly designed like hybrid bridge trust solves that problem at inception, like from the very first day that it's created, because it is like a Cook Islands trust. First, a bridge trust or hybrid trust is not a trigger trust. Like assets are transferred into the trust when it's created on day one, not later, not after the lawsuit. So we need to get the funding done right from the beginning, just like we talked about in the solo case. The foreign trustees also appointed from day one, actually named in the trust, not in a panic after a lawsuit. Courts want to see continuous relationships every year. They want to see you doing the due diligence on the client every year. And if duress or a lawsuit ever occurs and everything is set up properly, nothing is ever transferred. The trust is just one offshore trust from inception, and all the assets are already owned and titled under that offshore trust. So there's no retitling, there's no conveyance, there's no last minute move that a court can enjoin. So duress in like a hybrid trust causes a change of administration, not a change of ownership. And so all that's happening is that the offshore trustee who's on standby and pre-named in a trust is no longer on standby. And that's the distinction that matters for these trusts. That's the legal distinction that's being left out. You see, Fraudulent transfer laws target conveyances after a claim is foreseeable. They target retitling, things like that. Changing who administers assets already owned in a trust who are already named in the trust beforehand is not a conveyance. So the real lesson of both those Indiana investor cases are that they don't defeat hybrid trust or like bridge trust. In fact, they literally don't even talk about them. They defeat delayed execution, and they defeat trust that say like, don't worry, we'll move things later or create it later if something happens down the line.
Yeah, absolutely. Thank you for shedding light on something that I'm sure people should be more aware of.
Absolutely.
Awesome. So before we wrap up here, if somebody wants to reach out, connect, learn more, where can people find you and connect with you?
Yeah, you can jump on my website, www.btblegal.com. Got tons of free educational information there, resources, videos, over, 90 plus, you know, published legal articles, over 70 frequently asked questions on there. It's a great legal resource for people just to get through, look at the case law, see what's up with your specific state as well. Feel free to reach out to me via email, brian@btblegal.com. I offer a 1-hour legal strategy consultation. So if you're on the phone with me, this is going to be an actual legal advice. And then you have the option to decide how you wish to proceed afterwards from just a solid legal consultation.
Perfect. Well, appreciate your time and your perspective. Thank you for being here.
Yeah, absolutely. Thanks for having me.
Of course. And for those that are tuning in, if you got value, make sure that you have subscribed. We've got more conversations with operators like Brian who are building real businesses, and we'll see you on our next episode.
Thanks for joining us for today's Real Estate Pros Show. You can learn more about the amazing benefits of the Investor Fuel Mastermind community, including surrounding yourself with hundreds of other rock stars, 100% financing for your deals, and members-only discounts from vendors you're likely already using that, as a member of Investor Fuel, will save you more than the cost of your membership. Visit investorfuel.com to learn more. If you're interested in joining us as a guest of this show, please visit investorfuel.com/pros to apply. You can also check the show notes for access to free resources, how to get access to world-class lead generation, and much more. Don't forget to subscribe so you never miss another episode. Have a great day. We'll see you on the next show.